This is how it works, America. The prosecutor is now in control of the media agenda when it comes to the election. He files a 4-page piece of crap with the most radical judge in America in Washington, D.C. He files on a Friday night, and she demands that the Trump lawyers respond by 5 p.m. on Monday. And we don't know what she'll rule. It is the most phony act one can imagine. They're monitoring social media. Donald Trump puts out a social media post that has absolutely nothing to do with documents, has absolutely nothing to do with the protection of documents that are disclosed to the defense. And if they take that, they twist it, they file a 4-pager with a judge they have in their back pocket and say, this demonstrates that Donald Trump cannot be trusted with these kinds of documents. Therefore, we don't want to give them to him. And so the usual media hounds, that is, the people who support this revolution that's taking place in America, regurgitate it because they are the state media, which I say over and over and over again because that's what they are. Julie Kelly, who will be on the program next hour, is all over this. She says it didn't take long for things to get nasty in special counsel Jack Smith's case against Donald Trump for allegedly attempting to overturn the 2020 election. Yep. The former president already faces a nearly insurmountable challenge in receiving a fair process, let alone a fair trial in the nation's capital. Following the announcement last week that a D.C. grand jury indicted Trump on 4 counts related to the events on January 6th, Trump's luck went from bad to worse when the case landed on the docket of Tanya Chutkan, an Obama-appointed judge with a record of imposing the toughest sentences against January 6 defendants. In fact, Trump would have been hard-pressed to find a more biased, conflicted judge than Chutkan, who authored a landmark opinion denying Trump's claim of executive privilege and ordering him to produce months of records to the House Democrats' January 6 committee, arguing Trump was not a king. On January 6, 2021, hundreds of rioters converged on the U.S. Capitol, Chutkan wrote in November 2021. They scaled walls, demolished barricades, smashed windows, in a violent attempt to gain control of the building and stop the certification of the 2020 presidential election results. This unprecedented attempt to prevent the lawful transfer of power from one administration to the next caused property damage, injuries, death. For the first time since the election of 1860, the transfer of executive power was distinctly not peaceful. Chutkan presumably missed the 2017 inaugural riots in Washington, and when the president who put her on the bench conspired with the federal government's most powerful officials and agencies to concoct the Trump-Russia election collusion hoax intended to derail Trump's transition to president and ultimately oust him from office. Chutkan, however, has a keen eye when it comes. I think she wants to go on the D.C. circuit, so I think that's what much of this is about. Chutkan, however, has a keen eye when it comes to keeping tabs on Smith's fast-moving case against Trump. Smith's signature had barely dried on the 45-page indictment before his lawyers started to pick a fight over a proposed protective order guiding how Trump could access and share evidence. Jack Smith wanted Trump to agree that he would, quote, not disclose materials provided by the United States other than to persons employed to assist in the defense, persons who are interviewed as potential witnesses, counsel for potential witnesses, and other persons to whom the court may authorize disclosure. Let me just comment here. What that means is they want what is in effect a secret trial. They want the appearance of a Potemkin trial, that is, that it's open and above board, but it's not. They want to control the narrative. They want to control what information can be made available to you and me, the public, in the middle of a presidential election, in the middle of a Republican primary process. This unelected bureaucrat prosecutor is telling an unelected, radical left-wing Obama judge, do not allow the American people to see what we're doing. Trump's counsel did not agree. But as both sides were haggling over the details, Assistant U.S. Attorney Molly Gaston filed a motion late Friday night asking Chunkin to immediately approve the government's protective order, quote, without awaiting a responsive brief, unquote, from the defense. Now, nobody files something late at night unless it's a serious, provable national security concern, because the clerk has gone home. So just so you understand, this means that the government, Department of Justice, called the government, the courthouse, to alert them to an emergency filing, which the judge agreed to accept. That's how that works. And notice what she says, this Assistant U.S. Attorney Molly Gaston. She should do it, the judge, without even waiting for the defense to give their opinion, to even reply. So Trump's lawyer said, okay, give us till Thursday. And the judge said, no, 5 p.m. Eastern time, Monday. Gaston, the assistant U.S. attorney, claimed her ambush motion was in good faith. Smith did the same in the classified documents case and was scolded in Florida by Judge Aileen Cannon for failing to properly confer with defense before filing a proposed protective order. She denied Smith's motion as a result. By the way, there's a war on her, smearing her in the media. I want to get to that later. Judge Cannon. Issuing the protective order in quick fashion, Gaston urged, would expedite the flow of discovery in this case and give the defendant prompt access to a large portion of the discovery he ultimately will receive. But her filing was little more than a political stunt, as well as a low-key attempt at imposing a gag order on Trump and preventing the American people from seeing Smith's evidence against the former president. All right, let's step back. Is this the most nightmarish scenario that the Democrats have created here? They're putting Trump on trial for his freedom in the middle of an election. These are unelected bureaucrats who work at the Department of Justice. An unelected judge who's interposed herself into this process by not pushing it back to after the election. I'm going to get to this judge in a minute and all that this involves. Unbelievable. And then they say such a restriction is particularly important in this case because the defendant has previously issued public statements on social media regarding witnesses, judges, attorneys, and others associated with the legal matters pending against him. Why not? So what? I'll give you my footnote right now to Julie's piece. If the judiciary wants to be part of the election process by allowing itself, even wanting itself, to be part of the electoral process, rather than putting these cases off till after the election or dismissing them altogether, to be refiled after the election, then the judiciary is going to come under disrepute. And the judiciary is part of the campaign now. You can't have prosecutors making statements, filing stuff. You can't have judges making rulings and saying stuff in the middle of an election and then expect, oh, don't say anything, everybody. No, don't say anything. When the greatest impact on the election is the judiciary and their decisions, which is exactly why I've been saying for 2 weeks now, posting and saying, here, Fox, Levin TV, the judiciary should withdraw from participating in this election in order to protect the sanctity of the courtroom. It's clear this judge isn't going to do it. They need to get this matter to the Supreme Court, and there's a couple ways to do it. One of the ways I mentioned. They're not slam dunks. In fact, I don't even know how the hell the Supreme Court will rule. I'm not Nostradamus, but it's the only way out. If judges are going to participate, if the judiciary is going to participate on behalf of one party interfering in a presidential election because it controls the government, and the judiciary cannot expect to be treated with respect, the judiciary cannot expect to avoid the tussle and the back and forth of a presidential election. It's part of it now. The judge is part of it now. She's no longer your honor to me and the American people. No way. No way. Julie Kelly. But Assistant U.S. Attorney Gaston's filing was little more than a political stunt, as well as a low-key attempt at imposing a gag order on Trump. Such a restriction is particularly important in this case because the defendant has previously issued public statements on social media, she said, as I pointed out. Gaston then referenced a brief message Trump posted on Truth Social last Friday afternoon. Quote, in recent days regarding this case, the defendant has issued multiple posts, she said, either specifically or by implication, including the following, which the defendant posted just hours ago. If you go after me, I'm coming after you. As Julie Kelly points out, she's 100% correct. That's quite a stretch on Gaston's part, and even if Trump was in fact referring to those prosecuting him, he later insisted he was not. So what? He's supposed to remain close-lipped as a presidential candidate, facing unprecedented prosecution at the hands of his successor and 2024 rival? Who made Jack Smith king? Neither the timing nor the political nature of the government's motion bothered Judge Chutkan. The very next morning, she ordered Team Trump to respond to the proposed protective order by 5 p.m. tonight, giving his overburdened lawyers one business day to prepare a response. Trump's counsel immediately asked for a 3-day extension, explaining to Chutkan that negotiations were underway when Gaston abruptly filed her proposed protective order, and noting the court's rules allowing opposing counsel 14 days to file a response. An additional 3 days to brief this important issue is reasonable, consistent with the local rules, and serves the interest of justice. No party would be prejudiced by the requested relief, as this case is at its very early stages, and no matters are currently pending that require the immediate resolution of the motion. John Lauro and Todd Blanche, Trump's attorneys, explained emails between the parties were attached to the defense motion confirming disagreement on the proposal, but underscoring at least some degree of cooperation. And that's when the threats began. In a follow-up motion, U.S. Attorney Gaston warned Smith's office would not produce discovery, the government's collection of evidence in a case, until Trump's team agreed to the protective order. Quote, the government stands ready to press send on with discovery production. The defendant is standing in the way. The court should deny the motion. What a bunch of friggin' Stalinists. Judge Chutkan, to the surprise of no one, obeyed. She obeyed what Smith wanted. She denied the request for a 3-day extension and reestablished the deadline, 5 p.m. this evening, which has since passed. During a Sunday interview, Trump lawyer Lauro told CNN's Dana Bash why his client would not agree to the proposed protective order. We will not agree to keep information that's not sensitive from the press. Press and the American people in a campaign season have a right to know what the evidence is in this case, provided that this evidence is not protected otherwise. But Bash, along with her media cohorts and the Democrat judge, are unconcerned with the high level of secrecy sought by Smith's team in 2 unprecedented cases against a former president. Not only will Trump not get a fair shake in D.C., his trial in the court of public opinion won't fare any better at this rate. Now you know the whole story. Now you know. And look at the media. The Praetorian Guard media. The Pravda of America. Cheering on the Stalinists, because they are Stalinists.